Hey everybody, welcome to another episode of the OIG Roundtable. Of course, I have my two partners in crime, Wade McFall, retired assistant special agent in charge from the LA field office, and now one of the managers on our SIU investigative team, and Matt Kachansky, retired special agent in charge, executive level from HHS OIG, the retired Northeast UPIC director, and now the director of our payment integrity team. It's good to see you guys.
Good to be here.
I tried to get Jason to come on, but Jason is on another transatlantic cruise. And so he is he's in half retirement mode. So Jason, I hope you're doing well as you transverse the Atlantic.
SS Minnow.
Yeah, that was supposed to be a 3-hour trip. Look what that turned into. So so it's good to see you guys. So what we want to talk about today is kind of this intersection from kind of the criminal, civil, administrative investigation and that knowledge base that you need to understand laws, rules, and regulations, and then the importance of having a lot of that information from the SIU perspective. And we want to talk about one particular case that came out about a year ago, but is kind of creating a little bit of a stir in the False Claims Act world. It was a Supreme Court decision in 2023 involving the pharmacy SuperValu. And it basically changed the premise under which False Claims Act cases can be brought. The case involving SuperValu had to do with the submission of claims under Part D to the PBMs, ultimately to CMS, for what are known as the reasonable and customary charges for those medications, and that they were artificially inflated, thereby causing a false claim for that medication that was being provided. And essentially what the Supreme Court ruled in that case, and again, none of us are lawyers, at least the three of us aren't lawyers, so this isn't a legal analysis, but kind of the common sense review of the documents, is that the general feeling under the False Claims Act previously was what would be the objective reasonableness of a set of facts by a common person. How would you normally say objectively right, wrong, or indifferent? And what the True Value Supreme Court decision essentially came up with as a ruling was that you have to take into effect the defendant's subjective understanding of the rule or the facts or what have you. And so there's a little bit of a back and forth with that, because now, part of the argument is going to be what would have been the subjective understanding of that provider vis-a-vis the rules. And should the provider have known better versus some odd subjective understanding? And that gets to things like, did the provider in question have a compliance program in place? Did the team have current rules and regulations and access? And was their subjective understanding an actual misinterpretation of a rule? Or, how does that all factor in? But it really does then lead to, from the investigative perspective, the fact that investigators need to be a little bit more in tune with and up to date with current legal trends and case law that's out there, whether it be your district, your appellate, or SCOTUS, or the Supreme Court. So Wade, this becomes like an important piece, because if you think about it from the OIG's investigative purview and just in the law enforcement purview, it's not just reading an NCD, an LCD, or a policy. And it's not, from the law enforcement perspective, understanding what you can and can't do from that law enforcement perspective, but from the investigative piece of the puzzle, you have to be up on what's the latest and greatest in the rules of engagement, so to speak. And it adds in another wrinkle from an investigator's perspective on when you're doing, for example, a subpoena or a search warrant or doing an interview. It's now asking a set of questions that you might not have been able to ask. But, from the OIG's point of view, there were tons of resources, right? You have AUSAs, you have in-house Office of Counsel to the IG. There's a bunch of resources out there. So it now becomes another piece of that investigative puzzle that, it could just make your head explode.
Yeah, and back, at least when I was working with the OIG, and probably when you were too, we never really dealt with companies that had compliance plans. That kind of came after. That was never part of our investigation to find out if they had a compliance plan, which would then give you, a little bit of an edge towards trying to prove intent, because you can show that they had certain trainings and they had, updates on legal aspects. So that wasn't really a part of it. So we had to rely more on certain things that you would find maybe either in faxes or text messages that would show you're trying to show their frame of mind, that they knew that this was illegal, and they not just that they had like the Medicare sent them one of the memorandums that mentioned different fraud cases. You can't really rely on them having read that and understood it. So you had to kind of go a little bit further and look for things specific to them, whether it be conversations they had. And then if it's somebody just explaining a conversation they had, that's one thing. But if you had it in a text message or an email, that can go to show their frame of mind. What you really want to do is find something that shows that they knew that whatever the statute is protecting, or the statute is addressing, that they knew that it was wrong, and then they took steps knowing that to go ahead and violate the statute, even though that's the intent may not have been just to violate it, it's to get paid. But if you can show that they had knowledge, and sometimes you even we had some cases I could give examples of where we had to demonstrate that they not only had the information, but they understood it. And we had, in one case, we had somebody from the carrier call the provider who had some questions, was calling the carrier for some questions. And we had them fax the statute and go over the statute on the phone to show, because the AUSA was saying, well, we know that they probably got the Medicare memorandum. We don't know if they read it. We don't know if they understood it. So we had the contractor read it to them. But at one point, after reading for, several paragraphs, she just, instead of continuing, she got bored. She said, blah, blah, blah. And the AUSA had an issue that she didn't read the whole thing to him, because, there were paragraphs that she didn't read. Maybe he doesn't understand those, those paragraphs. So that's one example of where you really have to, it's difficult to get into their mind and show that they knew that it was illegal and they did it anyways. One more example I'll give you, which I think is pretty good. We had an undercover clinic where we had an agent acting as the clinic owner, and we had DME company owners coming in, paying kickbacks to refer patients to them, and not actually refer patients, just give them Medicare cards. So they're paying, again, we have to show intent that the owner knows that this is illegal. So they're paying us cash, and the undercover agent would put her hand over the cash and say, she'd have a couple different statements she'd use, like, we have to be very careful about this, or we got to make sure nobody else knows about this. And usually that would elicit some kind of confirming response, like, oh yeah, I know, or we're very careful, which kind of helps you, see what their frame of mind is. But we had one person who came in, she did the same thing. We have to be very careful about this. And we were pretty close to finishing the investigation on this guy, but when she put her hand on the money, he said, oh, it's not going to be a problem. I talked to my attorney. So now that's not saying it's legal. He's saying it's not going to be a problem. But the AUSA, we were back to ground zero. Like, we have no proof of intent on this because he thinks it's not going to be a problem. Again, his attorney didn't say it's legal. It's somehow an exception, but it's not going to be a problem. So we're starting from ground zero now on trying to prove intent on this guy.
And now you're kind of getting into an argument of advice of counsel, right? Like reliance upon advice of counsel, and that becomes a piece. Well, really, what you're kind of talking about is exactly the point, which is this fine line between a criminal case and a civil case. One thing that I did very early on in my career, and did it through my career, was if there was a potential issue in which the provider was violating a written policy, an LCD, an NCD, or something, one of the things that is common is that when there is a policy change or update, it gets disseminated out to the providers who it affects. The MACs, the Medicare Administrative Contractors, have a robust database of all the providers that have a Medicare number in that jurisdiction and their specialty. So if Dr. Wade McFall is a podiatrist and there's a policy that involves anesthesiology, you're not getting it because your specialty code is podiatry. So they're going to send you. One of the things I started to do was, if there was an issue involving a regulation change or something like that, I would go back to the MACs and I would ask the MACs to produce to me proof of an electronic service, because that's what they were doing. So they would have an email address on record. And Matt, you'll remember this, wait, back when they would do the Medicare updates and they were actual mailings, where you would have a list and you'd be able to, demonstrate that. And on a number of occasions, I was able to get from the MAC proof that the provider was on an active mailing list, that they got it, email. And then on one case in particular, a DME case, we did a search warrant and we found on the computer the emails with the policies attached. Like, that was just amazing, right? Because now you're showing that they got the policy, it was opened, right? We don't know who read it, but clearly, they had all those things. But that fine line between criminal and civil, knowing some of the way that the courts are ruling on things and evidentiary needs and the like are going to help you with shaping the questions to ask. And then obviously, how you're going to present that. But so Matt, this becomes so, while we're just talking now about kind of the OIG and the law enforcement and operationally, it's not really very different in the SIU space. In fact, the one part where I'll say it may actually be easier is after you've done the number one piece of simple due diligence, which is pull the contract between the provider and the plan, is then see if the codes in question have any updates on payment, and how are those updates disseminated to the provider to show, hey, they received this information. And you've got the good part is that SIUs are self-contained within the payer. There's no third party. You could walk right down the hall and get some of that information typically.
Sometimes it's more difficult than you think because the contracts tend to be very well protected. But yes, one of the first things we always do is we ask for the contracts for the providers, because there might be special instructions. We just did a project on unlisted codes, the use of the NOC codes. We found that for some providers, they were instructed to use those codes for certain procedures. And so, those cases went to the wayside because of it. So it's important to get that type of information. And the other is, I'm still going through with the subjective understanding. You said it was, there's a fine line between criminal and civil. I think that line is blurred now. You are looking for intent everywhere. No matter whether it's civil or criminal, you're looking for intent. And for an SIU, that's very difficult because sometimes you're not allowed to go out and interview the provider, or it has to be very specific types of interviews, and the resources to an SIU investigator is probably more limited than to an OIG or an FBI agent who has an AUSA that can instruct them on, these are the types of questions you should ask. This is the evidence you should look for on a search warrant or in a subpoena. SIU investigators really don't have that. They've got internal counsel they can use, but I don't know if they're going to be experts in this type of law. So, SIU investigators need to somehow keep track of these changes. If they're going to be building a referral package, they're going to need to know what evidence, what is needed to meet these new criteria. So, work with the corporate counsel, work with, maybe more experienced investigators, former agents that might be working in the SIU to get that type of information, because it's proving intent is the most problematic part of any type of investigation.
Well, and I think at the end of the day, Matt, from an investigator's perspective, it's not really an investigator's job at the end of the day to prove the intent, right? That's a prosecutor or a regulator, right? Yeah. But when you were thinking, and we always say this, that at the end of the day, as investigators, our job is not to make a determination if it's a fraud, a waste, or abuse case, right? Our job is to just say, hey, here is this problem we've identified. Let's talk about it. And if somebody outside of the organization, particularly because intent has that criminal element in the fraud piece, then the question becomes, what can you show to demonstrate that the person had this ability to circumvent something in an unlawful manner, right? So I think, part of the thing that we discuss with a lot of our SIU clients who are working these cases is don't get bogged down in identifying whether this is an F, a W, or an A. Right. Just work your case. because if you do that, you get bogged down with some of that minutia that is irrelevant.
Right, and I agree with that. But let's say the provider says, I've got a compliance plan in place. I'd rely on that. Does that end the game there in terms of, now you just might have some errors? Or do you have to go out and show that that compliance plan is just a beard? They don't actually use it. It's just, they're just paying somebody to sit there, that there is no compliance guidance being given. There's no quality assessments being given to any of the coding that's done. Is it just a beard? Does an SIU investigator have to go to that extent, or is it satisfactory just to hear, oh, I've got a compliance plan, and that ends the subjective understanding aspect of it?
Right. But it is interesting because I think when we talk to SIU investigators when working on some of our process improvement projects, what we hear quite often is that investigators are spending a lot of time trying to find something that proves intent versus just kind of globally working the case and then seeing where it ends up, spending less time on trying to figure out the intent and more time just working on that case itself, because people will get bogged down. I do think that when you're putting together your referral packages, if you're putting one together, there obviously should be a section on, if there is, anything that shows intent in your mind, right? Because even as an investigator, there's a subjective belief of what intent is, right? We're going to say, of course, they intended to defraud. But as investigators, we're always going to say that the bad guy, air quotes, intended to do this, because we're inherently, from the investigator's perspective, we're inherently pessimistic people. I don't know of any investigator who's optimistic. I'm investigating this and it's going to turn out well. They didn't do anything wrong. That doesn't really happen. And so I think part of the metric from an investigator's perspective is less being bogged down with the process of proving, is this an F, a W, or an A case? Just do your investigation. It's kind of like data is what it is. The facts are what they are. And you have to just kind of let it all fall in. And sometimes I think the biggest issue that I see, and Wade, I want to go back to you on this, is sometimes I think the biggest issue is that people are spending so much time hunting for that intent when the rest of the facts just show so much, just making it a W or an A case, and it's not really an F case, that you sometimes get this kind of myopic, narrowed view versus a more broader view of just kind of work your case and let the facts fall where they fall.
Yeah, I agree with that 100%. And also I've seen cases where there were certain standards that the investigators are supposed to follow. There's certain steps, like a flow chart, and at certain points there's cases that this is supposed to be referred as a credible allegation of fraud. And I've seen a lot of them with my past that I look at it and say, this isn't fraud. I don't see any indication of intent here. So that, as far as it being accepted for criminal prosecution by the Mafuku or something, it's like, I know it's not going to happen, but the regulations say this has to be referred, which is kind of a waste of time because it's going to go and sit with the Mafuku or the state for a month, 2 months, 6 months, whatever. And then we're going to get it back because there's no intent there. So it's not a fraud, it's a waste or an abuse.
Right.
With the one caveat being that maybe they can go out and do work that the SIU cannot do, some, whatever it be, surveillance, interviews, in-person interviews, that they could develop that. But a lot of the credible allegations of fraud that I've seen, passed up the chain and referred on, I know they're coming back because I can see that or I can't see any indication of fraud. So it's really not a fraud. So that's one issue I see where someone's telling you to label this as fraud when you don't have the evidence that there is any kind of really fraud. It really is a waste or abuse situation. So that's one area that I think maybe could be looked at, to have like a second reading on it and say, okay, this meets the criteria that we have set for referring it as a credible allegation of fraud, but it's not there, so we're not going to do that.
Well, and Matt, I want to go to you kind of to wrap this up, because one of the things that we've been doing here to help push that question about where it is, which letter does it fall into, is physical observations that we're now doing for some of our clients. Particularly, we just recently did one, and I think we talked about this previously last week, even, where we identified an instance where the provider had no patients show up during the day, and lo and behold, there were 90 claims submitted for services. And so, from an SIU perspective, it's like, whoa, hold on a minute, this is really a problem, and it requires very little other work, because really what you're getting is you've got a situation where the provider has clearly submitted fabricated claims. Nobody was there that day. How do we know? We had eyes on the place. And that really goes a long way. So there is this ability in the SIU space to kind of bridge that gap between the law enforcement piece and intent, and the SIU piece with intent, where you can really make an inroad to kind of get over that hump of, is this a F, a W, or an A case?
Right. And that the observational investigative activity, that's one way to do it. There are other ways, medical record review. Do the medical records look altered? Do they look doctored? Do they look do they pass the window test, or are they all this, are they all boilerplate where everybody's got the same temperature and blood pressure? That's indicia of intent to deceive. Similarly, just billing data itself. Are the patterns in the data showing an intent to deceive? Were claims being denied because it had a different diagnosis on it, because the procedure wasn't covered? Then all of a sudden the same claim is submitted with a different diagnosis and it gets paid. That
Right.
type of pattern is indicia
Right.
of intent. What you also have to do as an SIU, though, look to see, going back to this subjective understanding, were there things like something in the contract, an instruction from the plan that would give the provider reason to believe that what they're doing is okay? Whether it was the correct interpretation or not, you have to go and look to see what were all of the communications between the plan and the provider about this particular issue, to make sure that there is none of this miscommunication or something
Right.
that the provider can take advantage of to say, oh, I thought this was okay.
Right. Well, and the challenge is that when we're doing things that are indicia, right? Because we're saying indicia, parts of the puzzle that show that there's fraud, and the example of the cloned records, provider's going to say, well, the EMR system auto-populates, it's sloppy, I'm lazy, this is complicated, I'm an idiot defense, right? This is a female with a diagnosis of prostate cancer, right? A biologically born female, prostate cancer, like whatever it might be, right? Those are going to be where you have to maybe start to overcome some of these arguments of laziness or what have you. And on the diagnosis codes, right? It's really, I think, when you're making this pitch that this is a fraud versus a waste abuse, part of that discussion is also going to be, when you've got a change of diagnosis code or a continual resubmission of claims, is being able to explain that to whomever you're having to explain that to. I had a podiatry case where the provider was violating the routine foot care, the 60-day rule. And the way that they were doing it was they were rotating codes so that they could see the patient every month and circumvent the edit on the 60-day rule. And so, the data showed that. But you have to come up with some really good examples and be able to say, okay, here's how we know that he's intending to do this. Every month it's an E&M visit. Every month it's he starts with this code, and then it's this code, and then it goes back. And you kind of have to build those pieces of the puzzle to be able to explain it. So the takeaway that we want everybody to have is that this is really less about coming down to the minutia of, is this an F, a W, or an A? Work your case and then take a step back, look at your data, look at your medical records, look at your audit results, look at the pieces of the puzzle. And then if you are saying in your mind, hey, this is fraud, and this is what the intent was to circumvent the rules, here's how those were done. It's really it's laying out the story in a way that makes it understandable. Remember that if you're presenting this case, that it ultimately goes to litigation, particularly if it goes to court and you're in front of a judge, the chances of you getting a judge that fully understands the way healthcare fraud, waste, and abuse work, maybe not all that great. You may get a judge who's never done a healthcare fraud case. You're going to certainly, if you have a case that goes to a jury, you're going to have a jury who may not have a single clue about how any of this works. So it's putting that story together to be able to get from part A to part B to part C in understanding, is this an F, a W, or A case? But, the take home really is, unfortunately or fortunately, we've all got to become a little bit of legal scholars, to the extent of you've got to be able to read what the court decisions are and then speak to people about how those court decisions implicate or impact your investigations, your presentations, or whether or not you even have a case or not. Maybe you've got something that was a case yesterday, but because of a court decision, it's really not a case anymore. So you got to keep up with these things. And there's unfortunately no easy way to do it. It's a combination of press releases, blogs, social media, sleuthing, all those things. So don't get overwhelmed. Just keep doing what you're doing. So good seeing you guys.
I see.
Same.
Wade, next week you'll be plowing, I'm sure. Today you're out raking.
Yep.
It's
Raking.
gonna happen.
Back to snow in a couple days.
Yeah, well, you're
Well, if
in
you
a
let it
t-shirt.
snow over the leaves, you skip the raking.
Yeah, that's true.
That's
That
true.
sometimes
That's
happens.
All right, everybody, as always, we thank you for tuning into our weekly podcast and for signing up for our newsletter and joining us on the LinkedIn Lives. Again, get our newsletter, advizehealth.com, right off the website. You can sign up, get every week all that content delivered, including the OIG Roundtables. We're super happy that everybody tunes in. And Wade, I know you just told us, recently we're learning that more people are tuning into the podcast than we even knew. And so it's nice to see that. So to all of our friends at the OIG and law enforcement who are watching this, we appreciate it. To all of our SIU friends that are watching this and everybody else that's interested in fraud, waste, abuse, we thank you for supporting, and we'll see you on the next episode of the OIG Roundtable. Take care, everybody.